Everybody, welcome back. I am super excited to be here with immigration attorney Brad Banias, who I've known for a while and consider a good friend. Brad, welcome. Great to have you.
Good morning. Thank you for having us or having me. Happy to chat about how litigation can help.
Yeah, so let's start off for people that don't know about you. Share a little bit about your background and start wherever you want to start.
Yeah, sure. So as John introduced me, most people call me an immigration attorney, but I came to immigration a slightly different route than most immigration attorneys in that my first job as a real lawyer was working with the Department of Justice's Office of Immigration Litigation. And so right out of the chute, my job was to defend USCIS, Department of State, ICE, whenever they got sued around the country. And so I learned immigration law by defending these federal agencies in federal court around the country. And so I have done petitions since then, but the one thing I know how to do is sue the government when they delay or deny benefits or do crazy things like terminate SEVIS records. And so I've been on the private side now for more than 10 years and focus almost all of my practice on federal court litigation.
Excellent. And some of the recent work has been in the headlines in terms of, international students and their F-1 sudden terminations in SEVIS from ICE. Can you talk a little bit about that? And
yeah, absolutely. So, last fall, when we learned that there would be a new administration this spring, we've lived through one Trump administration. And so my wife looked at me and said, "Oh no, you're going to have to work for 4 years straight." And I said, well, we have to pick and choose our battles. And the SEVIS termination, I thought, was the appropriate battle for private attorneys to get involved and to really stop the policy through 1,000 cuts. And that was kind of the strategy that my colleagues and I went with, in that that first week of April, we learned about the terminations. I think by April 4th, April 7th, we had filed our first lawsuit with what's called a temporary restraining order. And those are the hardest things to get in court, because you not only have to show you're going to win, but you have to show that if they don't rule this quickly, the student will be, quote unquote, irreparably harmed. And that irreparable harm means something that cannot be fixed with money. So, classic examples: if you lose your immigration status, no matter how much money they give you, it's not going to replace your immigration status. And so within the first couple of days, I think we filed 12 cases in about 6 different jurisdictions around the country, because we really didn't know much. We didn't know the rationale. We didn't know which agencies were really involved. And so rushing to a class action or a big group case, we felt was reckless. We wanted to learn and see how it was going to go with individuals. And we were pleasantly surprised with the results, in that almost every judge granted the TRO. Judges from, we'll say, both sides of the aisle, Republican appointees, Democrat appointees. And we were happy to see it wasn't even really a close case. These judges were granting them, some of them without even hearings. And, last Friday, that culminated in ICE reversing its policy, right? And it reactivated all of the cases it had activated. Now, is that a big deal to them, right? Was this just a switch flip? Well, something we learned, what is today? Today's Thursday. On Tuesday, in a hearing in DC, is that this was a joint effort between the State Department and ICE. And essentially, State Department was driving it, and they said, "Hey, ICE, tell us who we can revoke." And so ICE took 1.3 million student records. So that's everyone on an F and an M that are in this database called SEVIS. and they literally manually compared them to a criminal database called the National Criminal Information Center, or NCIC. And if there was a hit between those two, they would terminate SEVIS. Out of the 1.3 million, they got it down to 6,400. So that's 0.49% were considered, criminals. And the NCIC further doesn't include only people who are convicted. It includes missing people. It includes people who are arrested, but no charges were ever brought. It includes people whose charges were dismissed. It includes people who got speeding tickets. And so the judge on Tuesday, Judge Reyes, basically said, well, if your only baseline was they showed up in this database, and this database includes people that have no real criminal history, don't you think that's inappropriate? And ICE basically said yes. And so this took them 3 weeks to do this comparison with 20 employees working full time on it, plus contractors. And so imagine the amount of money that ICE and the Department of State just spent to do these terminations. And then all of a sudden they had to go back and undo them all. So we think the litigation was a rousing success. Not just the individual cases, but the group cases, the 1,000 cuts, finally knocked them over. And the last little update I will say is they reversed and reactivated everyone on Friday, and then on Saturday they issued a new policy, which you've probably seen on social media. But essentially, this is, again, not a statute. Congress didn't pass it. It's not a regulation, meaning they didn't go through the necessary steps to make it a binding regulation. But instead, they just wrote up a policy. And that policy is far broader than what they did before. It is much more expansive. Essentially, what they say is, and this is the part that scares me the most, anytime State Department revokes a visa, ICE should terminate the SEVIS and put that person in removal proceedings. And visa revocation from the State Department has never had these consequences for folks inside the United States. This might sound hyper technical, but a visa is nothing more than that document that's actually in your passport. The only thing a visa is good for is to let you on an airplane, land, and seek physical admission into the country. But once you're in the country, your status controls, meaning I'm a F-1 student, I can do certain things, I can't do certain things. And so revoking the visa after you're in the United States historically has had no real consequence other than when you leave the US and you want to come back, you do have to go to the consulate and you do have to get a new visa. But it's never been seen as having consequences for you while you're in the US. And so the ICE policy, the new policy, seems to change that immediately and in very concerning ways, at least from my perspective. And so now the rest of the litigation is to try to stop that policy. But the good news is we can kind of go at a normal speed because everyone's been reactivated and can continue to go to class or can continue an OPT.
Right. Yeah, that's fascinating. I guess the good news in any of this is that they kind of tipped their hand a little bit with that memo. And so it gives you a chance to not be blindsided and a little time to prepare for round two, shall we call it?
That's right. And, from my perspective, they blew their credibility with a lot of judges around the country through these arguments.
Right.
And again, on Tuesday, I stood up and I go, well, Your Honor, we argued this is arbitrary and capricious, meaning it's unlawful. And the judge immediately said, well, I think we all agree it's not lawful. Like, that's a side issue. And that's a good thing, right?
That's a good thing.
But we've got to get these judges to make sure they enter orders that protect people going forward, because not only is the substance of these really problematic, but the procedure, the way they're doing it, is even more problematic.
Yep.
It might sound, again, hyper technical, but forcing the agency to go through the necessary steps to do a regulation is an incredibly important part of the process, because that's where the public gets involved and they have to address our comments, and they can't just do willy-nilly whatever they want. And essentially, I think they kind of got caught with their hand in the cookie jar here. It's somewhat embarrassing for them. And I think that hopefully we can get some orders out of the various courts around the country that basically say, look, you had no defense in this case, and this new policy has the same problems as the old steps.
Right. Yeah, we have a lot of F-1, a lot of students, visa holders in our program at eb3.work. And so this, I could only imagine the feeling that they have when they feel like everybody is against them, and so to have someone like you in their corner is fantastic. So thank you for all the work that you do with that. But let's I don't want to keep you too long, and I have a little sore throat, so my voice is slowly failing. But let's talk a little bit about some of the other work you do. Obviously with our program, those students go on to, after the perm, the I-140, then adjustment of status. So talk a little bit about your work in AOS delays and EAD delays and so forth.
Yeah, absolutely. So I would call it more routine work, but which is kind of nice. It's not an emergency basis. But essentially, for folks who are going through the EB3 process, adjudication delays are a weapon that the agency uses. They know that if they take 2 to 3 to 4 years, you're less likely to want to stay. Perhaps the relationship with the employer has changed. And so they use these delays to create attrition, right? To get people to stop. And so delay lawsuits are a very real thing. For work authorization and advanced parole, which are 2 benefits you can do when you apply to adjust status. We sue on those all the time, and they pretty much resolve after waiting at least 6 months. Okay. So if they don't get you your travel and work in 6 months, you might want to consider litigation. The more tricky issue is the actual adjustment of status case, because adjustment of status, as it has nothing to do with your actual job. It has everything to do with whether you're a criminal, terrorist, bad guy, this sort of thing. And so the courts have said, we'll give you more time for that, because we don't want terrorists to be let in the country. And so we encourage people to wait at least 1 year after filing. And I will say this, in 8 out of 10 cases, they will resolve adjustment of status delays, meaning they'll just decide it. But occasionally they fight. And, you got to be ready for the fight. You assume the fight, you prepare for the fight. And if they just settle, great. And I will say, we do our best, knowing what you guys are going through, to make these very cost effective, make them as quick as possible. And so, we leverage a lot of technology to make sure we can keep this affordable, and meet our clients kind of where they are. And so what I would say is, if you think this is something you're interested in, reach out. I think you'll find that it's more affordable than you think, of just hiring an attorney to sue the government. And so yeah, this is the kind of stuff that we're doing day in and day out and having very good results with.
Fantastic. And so just to kind of wrap things up, if anybody wants to reach you, what's the easiest or best way you prefer?
Yeah. So if you Google my name, you'll find my website, and we have a general inquiry box, just info@banislaw.com. And you can see how my last name is spelled on the screen here, a little strange. But Whitney or Mike, my staff, will answer your questions initially. And if they think, there's an opportunity to chat with me about a case, we'll do a quick talk. And usually we can get things moving in a couple weeks. With the uncertainties that the current administration brings, the best thing you can do to help yourself is be proactive on this stuff. And, there's one big lie that is out there that if you sue the government, they're going to take negative action against you because they get mad that you sued them. And thankfully, that's illegal. And 99% of the government attorneys who handle these, they worked for Obama, they worked for Trump, they worked for Biden, and now they work for Trump again. In other words, they're just civil servants trying to do their job. And these are not political or personal. They just want to get them resolved and move on. And so do not be scared to file these cases. The government's not going to come back and get you just because you sued them. And so that's why they're so powerful. And, just another tool in your toolbox to help you along your immigration journey.
Fantastic. Yeah. Retribution is often the first thing people think about when considering this. So thank you for addressing that. And I'll leave your info in the description below. Brad, thanks so much again.
Absolutely. Good to see you, John.
Hope to see you again soon.
Yes, sir. Thank you.